The next matter to come before the court this morning is Terrence Robinson-Bey versus the state of Ohio. State of Ohio has waived their appearance here this morning. So, Attorney Whitaker, you will have 15 minutes. You have ready to brief the ready to proceed to the court.
Good afternoon, Your Honors. Andrea Whitaker on behalf of the appellant Terrence Robinson-Bey. I'd like to begin and focus primarily in my argument today on the first assignment of error that we presented to the court, and that is the introduction on a continued basis of Mr. Robinson-Bey's criminal history in this trial. The most egregious introduction of that criminal history was when, during deliberations, Mr. Robinson-Bey's complete criminal history report, which was an 8-page extensive criminal history report, was sent back to the jury along with all the admitted exhibits. The court took possession of that because Mr. Robinson-Bey had waived his right to a jury trial on the RVO specification. So that exhibit was admitted only for purposes of the trial court's consideration for that. So as we detail in the...
Hey, before you go into yours,
Sure.
Was there a discussion about which exhibits were going to be sent back to the jury, and I'm assuming there was an objection made to those two, or was it just assumed that those exhibits 57 and 58, I guess, were not going to go back?
I believe there's a discussion on the record that those exhibits were admitted for the purpose, the court specifically indicated that those exhibits were admitted for purpose only for the RVO specification. There was not even going to be any exhibit on one of the Mr. Robinson-Bey's charges was a weapons under disability. And so there was simply going to be a stipulation that he had a prior crime of violence, so that there was not even a necessary admission of any judgment entry on that. So that those exhibits were specifically for the court's consideration for the RVO specification.
Thank you.
Certainly. So 3 times Mr. Robinson-Bey's criminal history was presented to the jury. The first and most egregious, as I indicated, was the submission of the lengthy criminal history that went back. And that was particularly prejudicial for several reasons. First of all, it was a lengthy criminal history. It was an 8-page document with charges as recently as 2 years prior to presenting to the jury that day. Additionally, it contained several charges that were similar to the charges that he was presently facing with the jury, making it particularly egregious that the jury was presented with those. And such as the firearms charges, the felonious assault charges, and the burglary charge. It's undeniable that this kind of information has the effect of causing a jury to find the defendant guilty. I've cited several cases where the court has indicated that this is what we know juries do. That's why it is so important that we take the steps to prevent this from coming into the jury's consideration. And one of the questions that was asked by the state in their brief was, why is this not harmless? Why does this matter? What's the fundamental right that we have here for Mr. Robinson-Bey? And for him, we have 2. He waived 2 fundamental rights to prevent the jury from having to consider his criminal history. First was his decision not to testify. And when the trial court specifically went over that with Mr. Robinson-Bey, as trial courts do, it specifically discussed the fact that if he testified, his criminal history would come up, would be presented to the jury, and Mr. Robinson-Bey waived his right to testify. He also waived his right to a jury trial on the repeat violent offender specification, again, so that only the judge would be considering his criminal history. So there are 2 very important fundamental rights that are impacted by the submission of that criminal history to the jury. The other 2 times that the jury was told about Mr. Robinson-Bey's criminal history incorrectly, and there's no dispute that the information provided to the jury was improper and that it was not supposed to be provided. The first time was testimony of the lead detective who testified upon direct examination by the state that Mr. Robinson-Bey had 2 prior federal convictions for bank robbery, I believe is what he testified to. Mr. Robinson-Bey's counsel immediately objected, requested a mistrial, and the trial court then incorrectly, unfortunately, compounded that error by herself indicating that she had already in her initial instructions and would be informing the jury that the defendant had been convicted of aggravated robbery. And in fact, if you look at the transcript, at that point, the jury had been told nothing about Mr. Robinson-Bey's criminal history. And it's later demonstrated in the transcript and cited in my brief that the stipulation was simply that Mr. Robinson-Bey had a crime of violence in his history. That's all the jury was going to be told. That was the stipulation. And again, what's important in terms of his fundamental right, while the state's correct, they do, if Mr. Robinson-Bey doesn't stipulate, have to prove these things beyond a reasonable doubt. There was a stipulation made. There was an agreement. And it was based upon that agreement, that understanding of what the jury was learning, that Mr. Robinson-Bey waived his Fifth Amendment right to testify and his Sixth Amendment right to have that RVO specification heard by the jury. So the state spends a good amount of time in their brief discussing what it had to or didn't have to prove, but it's irrelevant here because in this case, Mr. Robinson-Bey had stipulated to it, and that is that knowledge he had when he made those waivers of his rights. So the trial court, when it went to cure the detective's prejudicial statement of Mr. Robinson-Bey's criminal history, number one, incorrectly stated that the jury had already been informed of much of what the detective testified to. As I indicated, that's not accurate. The jury hadn't been told that, and a review of the transcript demonstrates that. Additionally, the trial court added in exactly what one of Mr. Robinson-Bey's prior convictions, and that was not meant to be part of the stipulation. So the attempt to cure was not only further prejudicial, it's also important to note that the state argues that any introduction of the criminal history was cured by these curative instructions. The most egregious submission, as I said, was the criminal history report. There was no curative instruction given. That was not discovered until after the verdict was rendered, when the attorneys were back talking to the jury after the verdict had been rendered. So there was no ability to provide any curative instruction to the jury prior to making its verdict about the criminal history that it received. So I think that that the most important thing to recall here is, again, that this is not a harmless error. Mr. Robinson-Bey relied on the fact that they were not going to be getting these criminal histories, his history, when he waived his fundamental rights. If there are no other questions, I'd like to move on to my assignment of error number 3. And that is that the trial court erred in denying Mr. Robinson-Bey's request for a lesser offense jury instruction. There were 2 jury instructions that Mr. Robinson-Bey had requested, and I think that both were legally allowed in terms of what the Ohio Supreme Court in Deem has said is required. Additionally, I believe that the factual basis was there for these jury instructions to be provided. The first one I'd like to discuss is his request for an unlawful restraint instruction. The trial court denied that request because it indicated that it believed that unlawful restraint was only a lesser included offense to abduction, and abduction was a lesser included offense to kidnapping. In fact, both abduction and unlawful restraints are lesser included offenses to kidnapping. So the legal basis under which the trial court ruled on its request for a lesser included offense was incorrect, because unlawful restraint can be a lesser included offense of kidnapping. It carries a lesser penalty than kidnapping. Kidnapping cannot be committed without the unlawful restraint also being committed, and the elements of force, threat, or deception, or for the purpose of terrorizing or inflicting physical harm on the victim, are not required to prove the commission of unlawful restraint. I think that the victim's testimony that when her liberty was restrained, prior to, the court will recall, there was some driving around in the car, and then they got out of the car, they went to a party, they went to a drugstore. It was prior to the getting out of the car and doing all these things. There was no force. She had no knowledge that Mr. Robinson-Bey had a gun. And I think that the factual basis that the court should have relied upon for the unlawful restraint instruction is also evident by the fact that the jury did not convict Mr. Robinson-Bey of kidnapping. The jury convicted Mr. Robinson-Bey of abduction. So the jury also did not believe that that element of kidnapping, the element of force, threat, or deception, or for the purpose of terrorizing or inflicting serious physical harm, was present, because they chose to convict of the lesser included of abduction. So I think that the elements that are important for consideration legally is the lesser included allowable, and secondly is the factual basis there, are both there for the lesser included offense of unlawful restraint. The additional...
The issue as to whether or not the evidence supported an acquittal on the kidnapping, that wasn't the testimony that he restrained. Had a gun on her, restrained her while she was in the car, etc., threatened her. I can't remember the specific facts. It's been a little while since I read that brief. But
certainly, well,
what
first
is
of
the
all...
evidence that would support an acquittal on the kidnapping charge?
Well, first of all, he was acquitted of the kidnapping charge. He was only found guilty
Of the abduction.
Of the abduction.
Okay.
So I believe that the jury did find that there was no, those elements of the threat of force or the physical harm.
And you did argue that, so.
And I think just to, in terms of factually clarifying, she testified she did not even know that the gun existed until after she had gotten out of the car. She didn't see the gun.
She was shot.
She was shot, so she did, but she didn't know it was there. He wasn't holding it on her. He wasn't threatening it with
There's
her.
only two of them in the car. She gets shot in the leg while she's in the car.
Yes, she got shot in the leg as she was getting out of the car. So she did not know that the gun existed. She did not know that threat was there. And it's that knowledge of the threat to her that is that additional element of kidnapping. And again, the jury didn't find it. It found her. It acquitted him of the kidnapping charge.
Thank you.
If there are no other questions. So the other lesser included offense that we discussed was in the brief is negligent assault. But if the court doesn't have any questions on that, I will move to another assignment of error. The next assignment of error I'd like to address is the fourth assignment of error, and that is the irregularity in the proceedings that created a structural error, and this assignment only goes to the repeat violent offender specification. And this was the trial court not having rendered its verdict on the RVO before going back and talking to the jury, and specifically discussing with the jury the facts of Mr. Robinson-Bey's prior testimony. I provided the court with the cases of Marzette and Davis. I think that particularly instructive is the Marzette case. In the Marzette case, that Court of Appeals and that trial court did not even know what the trial court had discussed with the jury. It found just the fact of a conversation between the trial court and a jury prior to the trial court's deliberation on the count that was before the trial court. That in of itself was a structural error that caused a reversal on that particular conviction. And it was plain error, it was a structural error, therefore it didn't need to be raised by the attorneys at the time. Here we have more than the court had in Marzette. We have the trial court putting on the record in its first sentencing hearing that in fact it did discuss Mr. Robinson-Bey's record with the jury when it went back and had its discussions. So we know that the trial court is discussing what is in fact the factual basis for a verdict that it has not rendered yet. And we believe that is structural error rises to the level of plain error because as we acknowledge it was not objected to at the time, but we do believe that it requires a reversal of the trial court's conviction on the repeat violent offender specification. And then finally, Mr. Robinson-Bey's assignment of error number 2 is his conviction for the abduction. And that is the jury instruction allowed the jury to convict Mr. Robinson-Bey on a non-unanimous verdict. In other words, there are two different types of abduction that the statute allows, two separate elements. One is that it is by force, threat, you remove from a place where the other person is found, or by force or threat, restrain the liberty of another person under circumstances that create a physical risk. These are two separate crimes with separate elements that must be proven to a jury beyond a reasonable doubt. However, the jury's instructions allowed the jury to rely on either one of those elements to convict under the abduction. So this is not a situation where the jury is allowed to rely on potentially two different means by which one crime is committed. For example, there were two different times in the car that maybe somebody alleges by force or threat they restrained the liberty with risk of physical harm. That's one element, and there are two factual means by which that element is accomplished. That's permissible. That's not asking the jury to find somebody guilty without unanimity, a unanimous verdict.
So there was evidence of both? Force and threat used to remove, force and threat used to restrain the liberty?
I don't believe that there was evidence of the, of number one. She testified that she got in the car not by force or threat. She testified that she was unable to leave. He wouldn't stop. She asked to stop. He wouldn't stop. So I don't believe that there was evidence of that. But regardless, even if there is evidence in the transcript that both are a possibility, they are two separate crimes and the elements are what's different. If, again, a jury is invited to convict on two separate means of committing the crime, two factual scenarios that both comprise the same elements of a crime, that's permissible. But what we have here is a jury instruction that invites the jury to rely on elements of a separate crime to find the single crime of abduction.
Now, was the jury instruction that was read the OJI verbatim?
It was the OJI verbatim, but what the OJI says is pick an alternative. The OJI, as the court knows, has in the parens and italics the instructions to the attorney or the court to how to present those. And so it says to do that, to pick an alternative. And what the court did was just provide the entirety of the OJI instruction without picking the alternative.
Would your argument be the same if there was evidence of both the force and threat to remove as well as the force or threat to restrain?
It would be the same, because what we have here again is two separate crimes with separate elements that the jury has been invited on.
I think you're out of time.
Thank you very much for your presentation today.
Thank you.
We will take the matter under advisement and issue a decision which will now to both sides, as well as post tomorrow on the Sunday night Supreme Court.
Thank you. Have a good day.
Thank you.